I'm Rob Caves. I'm a shareholder with the firm. I'm located in, Fort Myers, and I have two other panelists who are going to join me for this presentation, Rosa De La Camera and Dave Rogel. Rosa and David are both primarily located on the East Coast of Florida. And we all have a little bit of a different perspective and experience in dealing with terminations. In considering this topic, it was originally scheduled before Hurricane Ian hit, my part of the state. And really, the thought behind this topic was in response to questions and concerns that had arisen because of SB4. While Senate Bill SB4D does not, in and of itself, discuss or really address termination issues, it raises questions concerning condominium and cooperative building and associations who, may have significant expenses in order to comply with the new requirements of the milestone inspection reports and the new requirements concerning reserves, that it may cause associations to look at termination. So while that's maybe a motivating factor for this part of this discussion, we're not going to talk about the terms and the provisions of SB4. We've done other webinars concerning SB4D, and those are available, and we'll be doing more in the future. But this is really looking at if you had a building that is now considering terminating, what does that process consist of? What does termination actually mean? And what do boards need to consider if they're, looking at that as an option? So, before we open up to specifics, Rosa and David, do you have any other kind of opening thoughts or comments on that?
Yeah, Rob, I would just say that, again, there's a lot of reasons why a community would be interested in this, both the program and certainly the issue. Again, the concept of termination, which again, for a lot of folks means how do we sell our condominium, is a very technical process. And yet there's a lot of open and unanswered questions in both the law and in practice, so that while, for instance, I've probably been dealing with termination since the mid-90s, the kinds of things we see now are completely different. Sometimes as a result of things like the hurricane that you all suffered in Fort Myers, but also because of the fact that land values have dramatically increased to the point where the property is not being used for its highest and best use, even if the residents feel like they have a nice place and they want to keep it that way. The pressure of real property valuations certainly makes this a timely topic.
Yeah, and I just wanted to say along those lines that Florida has a very healthy termination statute in the Condominium Act, Chapter 718.117. And there's essentially, the big picture is that there's two types of termination. We've always been familiar with the optional terminations, at least I'll speak for myself. But when there's a casualty such as what occurred by Hurricane Ian on the Southwest coast, we see more now focus on the terminations due to economic waste or impossibility or the sheer devastation. So I want to be sure we cover both of those options today. And I don't think David may agree with this, but for myself, in the last 2 years of my career, I have seen more termination conversations than I have in the rest of my career put together. He perhaps has dealt with it more earlier on, but I've seen so much interest and enthusiasm for terminations that I think this topic is really very timely.
Yeah, I agree with that. We're definitely, even before the hurricane, there were communities that were at least concerned about the idea of termination, given the requirements that will be imposed upon associations through SB4. In my experience with termination in, prior to SB4D and prior to the hurricane, was assisting associations in partially terminating where condominium buildings had been destroyed due to fire, and there was insufficient insurance proceeds to rebuild, and the associations, essentially terminated just those units contained in those buildings. So it's kind of going back to your comment about the types of termination, that's under that first category of impossibility or due to casualty loss versus optional termination, which I think is what we normally see, where the underlying land has a higher and better use value than the building that's on it. So some developer wants to buy them out and build something else. And how do you do that? So,
Sure.
Kicking off from there, and I'll start with David and then get Rose's comment, explain what is termination.
All right.
We use that term, but what is it?
Thanks, Rob. And again, you're correct. My experience over the last, I guess, almost 30 years in this area, thus the gray hair, is developers who come in and say, hey, we want to buy your building. So termination, and incidentally, a lot of the questions asked some very pointed questions about termination and dissolving the condominium. So we start with the fact that you, as a condominium association, are a corporation. You're either members, board members, or managers of a corporation that operates a condominium. Condominium ownership is a form of real property ownership, wherein when a developer develops your property, they take a parcel of land and they build a building or subdivide the land into lots, and they create a condominium. That's your declaration of condominium, and it contains a lot of important provisions. Almost every condominium document declaration has a termination section. Then we deal with the corporation. The corporation runs the property and collects assessments and whatnot. That corporation is operated by the articles of incorporation and bylaws of your association, which don't have anything to do with termination. But if you ever terminated, your condominium association would be dissolved. So let's talk about the fact that dissolving is dissolving the corporation, whereas termination takes the property out of the condominium form of ownership. So realistically, what most folks hear or understand is somebody wants to buy your property or you want to sell your property. And as a condominium, you can't. Everybody in a condominium owns in undivided shares their property. Most condominium documents prohibit what we call partition, which we'll talk about in a little while because that's part of the termination process. But again, you can't sell. We have board members call us up all the time. We've received some offers to buy our condominium. What do we do? One of the first questions, and incidentally, one of the questions from one of the registrants is, what do we do when we get those offers? Do we have an obligation to do something with that? And my answer is yes. You have an obligation, in my opinion, not a legal one, but let's just say a fiduciary obligation to tell your owners that somebody's interested in buying the property. The next thing you do or have to do is figure out whether or not anybody's interested, because it takes when we talk supermajority, when we talk about amending the governing documents, this is a much higher supermajority. Most condominium documents talk about terminating a condominium when there's either 80% approval or up to unanimous approval. And the statute talks about having 80% approval and no more than 5% objecting to termination, which in essence, based upon the statute, means 95%. And I'm talking about optional termination where somebody comes in and says, I want to buy your building. In the end, what happens with termination in the optional sense is that developers don't buy your building. What they do is they buy individual units. And as long as they're sophisticated enough to understand that, the first idea would be to figure out whether your community is interested in that process, whether it be because the amount being offered is substantially more than what an owner might be able to sell their unit out on the open market, or because the expenses that are upcoming whether they be recertification expenses, SB4D expenses, expenses to rebuild as a result of a hurricane. All of those things may play into whether owners are saying, look, I always liked the place, but it's time to leave. It's time to get out. It's time to sell. So termination is the process by which the property leaves condominium form of ownership and can then be sold.
And Rob, just some general thoughts on optional terminations and what we've been seeing down here in my neck of the woods in Southeast Florida. We mostly get approached by association clients, board of directors who've been approached by an interested developer. Look, there's a very limited amount of waterfront property, and there are certain prime locations that developers are very interested in purchasing. They are willing to pay top dollar, and they are oftentimes willing to pay a significantly higher over market value price for the units and for the condominium common elements. Remember, as David said, the condominium association through its board of directors cannot sell a condominium. The condominium association does not own the building. The building and the condominium is owned by each and every single unit owner in the proportionate share that they pay common expenses and that they own their units, and that they share and that they own the common surplus. So a developer may approach an association, and we've had many clients who've been approached by developers who want to buy the unit, buy the condominium. What they will do is they will enter into individual contracts with the owners with the clause saying, an escape clause, if you will, if I don't reach the necessary threshold of sales and purchases with these owners such that I can then vote to terminate, I will rescind all of these individual contracts and I will owe no obligation to those owners with whom I've contracted. And that escape clause for the developers is important. And we just went through a very, very large project, which ended up falling through. And in that building, I might add, they were very smart about it. It actually ended up falling through, but the way they approached it is they went to a commercial real estate broker, a very large entity. I'm not going to mention names, but you all know these large commercial real estate brokers, and they actually shopped it on the international market, and they got a mammoth offer. And the owners were probably getting well over 200% of the value, close to 300% in some cases for their units. And that makes for a very attractive proposition for the owners to enter into these sale contracts with the potential developer who would then buy, the units and the entire parcel. Remember, you're getting top dollar as well, because you're not just selling your unit to a random purchaser, you're also selling your proportionate share of the common elements. So there's, a bang there to the buck that needs to be considered.
So that's a good, go ahead, David.
No, just sure, go ahead, Rob.
Well, I'll just say that's an important distinction in the example you gave, Rosa. The association was essentially shopping itself or its property to developers versus a developer approaching an association to purchase it. Because I think what we've seen historically is, I think the example that Dave was giving, which is where developers are really driving the purchase of the property, where I think what we're going to see more of is the example Rosa gave, where associations are looking at shopping their property. I think those are a little different.
Yeah, I think, Rob, that really it's, first off, there's no doubt that owner-controlled associations will be looking to shop or to market their property. But it should be clear to everybody the termination is or the sale of the condominium isn't going to happen for most communities. Now, again, we want to make it very clear that when it comes to a casualty loss, in most cases, the condominium documents contain provisions regarding what happens when the loss is significant enough where you might want to think about termination. And in many cases, the documents require a condominium to terminate when the vast number of units are uninhabitable. But that process is one which, again, may very well contain provisions that doesn't give you a lot of leeway. you have to terminate. Unless the owners vote to keep the condominium and rebuild, you have to terminate. And under those circumstances, whether there is a buyer out there that's interested or not, you have to terminate. Of course, even then, the driving force in termination is the interested buyer. Without an interested buyer, there can be no real seller. Even 718.117, and it should be noted that 718.117 that Rosa talked about, the statute, which has been in existence for decades and has changed dramatically in the last 15 years, that statute doesn't always apply to the termination of your condominium. There are two places you would look to determine how you terminate your condominium: your own condominium documents, again, your declaration, and the statute itself. The statute was designed, or at least the legislature seems to have intended, that the statute applies to every termination. It does not. And the statute changed a few years ago to make it even more clear that the statute governs everything. In my opinion, it still does not. And there are many nuances that I've worked with developer attorneys to get them to understand and to get the courts to understand what applies in terms of how you terminate your condominium. But again, without somebody willing to buy, you're not going to sell. And even in those terminations where the process was begun by a hurricane or a fire, the fact is that you're still going to need somebody to buy that property. Otherwise, it'll just be a piece of property owned by the owners without a condominium form of ownership. And nobody would want that. There's a lot of reasons why nobody would want that. But in those cases where you may be in a property that's been destroyed and there's not a lot of development pressure where prices are going to be a lot, you may still have to sell to somebody who says, hey, I think I see a bargain here. I know that these folks are going to have to spend a lot of money because the insurance is not going to cover everything. And I think I can make a deal. Listen, I want to help them out. They always say that. They want to help them out. No developer is there to help you out. You know, they're there to make a profit, to redevelop, whether it be to knock down a building and build something new, or to turn a building that is a condominium into a rental property. Rental prices are way up. So we're seeing a lot more properties where the developer is interested in just converting to a rental building. And that's good. That's good for people who are not along Millionaires Row that Rosa talks about, because those are inland condominiums and the rental market is hot everywhere. But you do need a seller. And one of the ways to get a seller is to go out to a CRE or commercial real estate broker. Now, again,
you need a buyer. You mean you need a buyer?
But again, the CREs are not always going to take on an property unless they think they can make a profit. Everybody's out to make a. Incidentally, I'm not denigrating developers. They are part of our legal land and landscape. And they make a profit. That's what they do. That's not bad. Commercial real estate brokers, somebody who might market your property, are going to be there to make money. They're there to make a percentage, just like a typical real estate transaction, which is why sometimes you don't want a commercial real estate broker involved, because if you have a developer who is really paying top dollar for your property, you don't want to cut in somebody else. So those are all considerations.
Rob, I'm sorry, can I just make one comment? I want to highlight something David said, which I think is incredibly important. I want to make sure we don't gloss over it. This is relating to the non-optional terminations, or those terminations that are as a result of a casualty. You and I, Rob, are doing a lot of work on the Hurricane Ian files on the West Coast. And I would say it's more prevalent really in the West Coast documents that I've reviewed than on the East Coast documents. But I will say I have seen several condominium declarations that do mandate a mandatory termination if the damage is significant enough. You know, that means that the owners might not be aware of the fact that in 60 or 90 days, their condominium is going to be overdone, dead, kaput, if they don't rally and move and call a meeting and take a vote. Why? Because the Declaration of Condominium says if your condominium suffers significant damages or damages to more than 50% or more than damages to 75%, whatever the threshold is, of the property, you must call a meeting and you must get X amount of owners, 75% usually of the owners, to approve rebuilding. Imagine the, I don't know, liability or the outcome even if the board doesn't move quickly to call a membership meeting to get that done. The other problem with those provisions is that it is very murky and unclear. It talks about the units being untenable, untenable, uninhabitable, significant damages, all words that are very fluid,
Right.
that are very subjective. So my point is, I need everyone in this seminar to go to their declarations of condominium and look at your termination or your reconstruction after casualty provisions. Familiarize yourself with those. And if you happen to have a provision that requires a mandatory termination absent a vote, you may seriously want to consider amending that to remove that what I consider bad language, and to at least give you A, more time, or B, not to default into a termination if it's not what you want.
No, that's a great point. That was actually the point I was going to go to, because we're seeing a lot of that in older and original condominium documents here on the West Coast have, the after major damage from a casualty event, the default is termination. And what we would recommend in an amendment is the default would be reconstruction, and you would have a vote that would allow termination, kind of the reverse of what these old documents say, because we have a number of clients that are having to take votes, but before the 27th of November, which is, I believe, the day after Thanksgiving, to prevent their automatic termination of their condominiums, because that's what their documents say. And that,
Right.
that's kind of compounding the tragedy if you're in that
Sure.
situation and your documents were terminated. Before we get to something David had started to talk about, which is the statute applying and not applying and what the courts may say, Rosa, I want to talk a little bit about 718.117 and the statutory provisions on termination. You mentioned before there's optional and mandatory, termination due to economic waste. Can you kind of just give us an overview of the statute a little bit, and then we're going to talk about, when it doesn't apply, maybe.
It's a statute, just like I recommended everyone to go back and read their declaration to see what happens after large casualty loss. I do recommend you look at 718.117. There's a lot of legal jargon and gibberish in there, but really it's a good statute to be familiar with. There are essentially, Rob, as we said, two forms of termination, and one of them is, it's called termination because of economic waste or impossibility. And the other one is called optional termination, as simple as that. In the optional termination, which again is what we have traditionally seen more, someone who gets approached by a developer with a sexy new project, getting rid of the old building. In those optional terminations, the statute says that you need the approval of, quote unquote, at least 80% of the total voting interests. However, if 5% or more of the total voting interests reject the plan of termination may not proceed. So it's sort of like a dual test. Now, does this provision, as David was saying earlier, does this provision apply to every building? Not necessarily. And I'll tell you, there's an analysis, really a legal analysis that has to be done for each and every single condominium as to whether this optional termination language of 80/5 applies, or if your document provisions apply, or perhaps even if the statute which was in place at the time your documents were recorded is what applies. So there's essentially multiple possibilities. And it's really impossible to tell you on a webinar what applies to your condominium without telling you that it has to be analyzed, one by one, because they're all different. And I think, David, I would defer to David to, beyond the votes and beyond the internal process of the membership voting for the termination, he's handled a lot of post-vote procedures. And, he's done the partitions and what have you. So I'm going to ask him, I'll defer to him to weigh in on that part of it.
All right, well, before I go to post vote provisions.
Before we go there,
that-
not to cut you off, but there were some questions in the chat I want to just touch on about.
I've been looking at them as well.
One of them was asking about, termination provisions for 720 and 719, the Homeowners Association Act in 720, and the Cooperative Act in 719. And there isn't a similar detailed termination statute.
Yeah,
I think
it's fair to say that, and again, reminding everybody, because I know we have a lot of folks registered, this is Florida condominium law, not another state. This is not cooperatives and homeowner associations, because they do not have termination provisions either in the statute or typically even in the cooperative or HOA documents. Because of the way they are owned, that's the reason why they don't have those provisions, because homeowners associations, each lot is owned by an individual homeowner and the common area is owned by the association. A co-op, the entire property is owned by the association, and owners don't, quote unquote, own anything. They have an exclusive use right in perpetuity for their cooperative unit. So, and you would say, well, that makes it easier, Dave, doesn't it? No, it does not, because I've dealt with a number of co-op terminations. But again, that would be far afield of this discussion.
Right.
So let me go back to say one thing. Yes, I'm involved in a lot of terminations. Incidentally, Rosa and Rob, terminations after Hurricane Opal in the Panhandle, those condo docs also had these similar sunset provisions to terminate. Same thing in the Florida Keys, where I do a lot of work. I had a condominium that did in fact scramble after Hurricane Irma within 90 days to get a vote of 75% of the owners to rebuild and not to terminate the condominium. So not only is it in Southwest Florida, but it's all over the state. Now, going back to optional termination, and Rosa puts it in the perspective of after a vote. More likely than not, if you are a condominium association that because of any number of reasons is going to look to termination and has a person, entity, or multiple entities that are interested in buying your property, and even if the statute applies, or even if the condo docs apply to termination, you will likely never take a vote. That's just not the way it's done. What's done is a developer, as Rosa aptly points out, a developer, after they get an understanding of what the community is going to need in terms of dollars and what their development rights might be if they terminated and decided to redevelop, they will then go to the individual owners. And depending upon whether the condominium documents and a percentage within them apply, or the statute and the percentages there apply, and again, Rosa's point is valid, we have multiple different versions of the Condominium Act, and the older condominium documents, many of those will require you to terminate in accordance with the act at that time. But even the act at that time, which typically said 100% of all owners, or as the declaration provides otherwise, brings you right back to the declaration. But getting back to my point is that you're never going to take a vote. Developers have no interest in having condominium associations control the destiny of their effort to acquire property. What they do is, once they figure out what they might be able to do in terms of development and how much they can spend on the acquisition versus how much they might have to spend on demolition or modifications to the building and rebuilding the building in some other form or some other type, some other height, some other number of units, whatever the case may be, they're then going to go out and enter into contracts with the owners sufficient to get them to a point where they control the vote, because they will be the voters. And they typically, when you see a contract between a developer and a unit owner, and again, they're not looking to one unit owner, they're doing this with all owners, their contracts will contain a number of dropout clauses or contingency clauses. One is the obvious. If you need 80% to terminate, they are not going to close on your property until they are under contract with 80+% of the units. If you require 95%, ditto. Now, in some cases, and one again that Rosa and I recently worked on, the developer said, we think the statute applies, we think we need 95%, but we're willing to close for less. We're willing to take on the risk that we can finally obtain enough units to get to that 95th percentile. But the dropout provisions that you typically see in these contracts include the requirement to for the developer, once they've entered into the contract, to have a due diligence period. Due diligence periods can mean anything from whatever we want. We can, in 90 or 120 days, we can just decide not to buy, to a contingency that requires site plan approval of the new development. And site plan approval, typically in those contracts, site plan approval will indicate site plan approval through the appellate process, so that if any property owners in the area challenge what the city or county may have done in terms of approving a site plan, and somebody challenges it, there are appellate periods. I've seen a successful termination where the contracts get to the point where they've got more than the percentage necessary to terminate. Yay, that's the first step. They go through the site plan approval process. Yay, they get that. When do they get that? About 200 days after the original contract was signed with the owners. So it can stretch on for quite a while. Another big aspect, again, because there are always going to be conditions. A lot of developers will say, oh, here we're going to offer every owner a contract and there are no contingencies. You'll never see that. If they say it, they're not telling the truth. But again, one of the bigger picture items, and what's happening now in our society and in our economy, is that property values go up and down. And so one of the things that might happen is that they finally realize, even though they have a percentage of contracts necessary to terminate, that they don't have the ability to make the money, or they don't have the ability to borrow the money they need in order to redevelop. And so these are all things that occur in the process. But if, in fact, they get enough contracts to buy enough of the property, and the contingencies either are something to discuss in the future or something that has already been resolved, there is a process after getting enough units that I can talk about. But I see a lot of questions, Rob, especially I see a number from the Fort Myers area. I see an interesting one, which I think I would, again, I want to get back to what I'm talking about, but Rob, because of your experience in partial terminations, I see one question that they have: two buildings, one's been destroyed, one's fine. What do we do?
Sure. So we'll go there, then I have a question for you. But there, if you had a situation where one building out of a number of buildings in a condominium is destroyed, one, as we've already said, you have to look at not just the statute, but what do your documents say? What is the default under the documents for repair after casualty? If it's just one building out of multiple buildings, it's probably less than substantial damage, and the default would be to reconstruct. Then the issue becomes, if there are this is the experience I've had, there are insufficient insurance proceeds to rebuild the building back because you have to bring it to modern code, or Other changes to reconstruct the building is going to be very expensive. So the owners collectively, choose not to do that. There's a process in the statute that provides for optional termination. And assuming you can operate under those provisions, and again, that's an analysis of your documents as well as the statute, you adopt a plan of partial termination, where you essentially take those units out of the condominium. And if you had a 40-unit condominium and 10 units are taken out, you now have a 30-unit condominium, and you have to record amendments reflecting the new number of units and how those units share common expenses and common surplus, et cetera. And then you have to provide for what are you doing with that underlying property that was the condominium building? How was that property originally dealt with? In one example, it was, condominium property became common elements. In another example, the units were actually parcels made up of a multi-unit building. So that had to be addressed differently. So the short answer is there's a way to restructure the condominium with those units removed through a partial termination, which is, again, specifically provided for in the statute, but you're going to have to see how your documents would treat that. And, one option might be amending your documents to incorporate the technical provisions of the statute. Going back to what you were talking about, David, and the experience of where developers are buying the units directly from the unit owners to the point where the developer owns enough units that they can, essentially control the process. I mean, that's,
Sure.
There, the unit owners are being compensated for their units directly by the developer through the sale of their unit. It's really no different in that respect from them selling their unit to any third party on the face of the earth. And that's different than what termination under the statute would contemplate if you actually went through a statutory termination where there was a plan of termination and proceeds are then distributed. How are the proceeds distributed there? That's different.
It really isn't, Rob. When the condominium statute applies, they still do the exact same thing. They are not going to have the unit owners vote on termination. They'll acquire enough property where they will control that vote. They will acquire the units. They will take the vote and they will distribute to themselves.
And I wanted to also mention that, and Rob, you actually, both of you touched on it, is on the plan of termination. And even though, David, you're right, that there's no membership vote per se to terminate or not, the members do have to approve the plan of termination. And, I wonder, in your experience, does the timing of the approval of the plan of termination come before or after? Because the plan of termination has to include a lot of meat, a lot of provisions in it. And so does it normally get approved ahead of time by the individual owners, or in your experience, does that extremely important plan of termination get approved by the developer with the developer owned units?
Again, the latter, absolutely the latter.
Yeah.
So the developer will buy the units that they have acquired with the percentage they think is appropriate. And the cram down, if you want to call it that, the cram down for the people who don't want to sell will be the plan of termination that the developer, through the developer controlled board, will propose a plan, will vote on the plan, will approve the plan with their votes, and the members who have not sold will be subject to the requirements in the plan to convey through a trustee. And again, trustee can be the association or any entity. The developers do not want a unit owner controlled association to be involved in that process. They'll create the plan, they'll write the plan, they'll vote on the plan, and the vast majority of the owners will be long gone with cash in hand.
So in a way, the takeaway to me is, number one, there are owners who are not going to want to terminate and are not going to want to sell. If enough owners allow or approve the sale in terms of agreeing to, to enter into a contract, those owners who are in the small minority are going to get swept into this and almost against their will, forced to sell their property. There is something to be said about the holdouts, because whether or not we should make this public knowledge, in our experience, I think we can say sometimes holdouts get a bigger check, just because by the time you get to the holdout stage where there's only a few left, developers sometimes cough up more money. But
Right.
once you get the holdout vote, there still may be a few that don't want to terminate. And what happens with those? Is that just basically left to the mercy of the court?
So under the plan of termination, it's not to the mercy of the court. It's to the plan of termination. A plan of termination will in fact say the property, the entire property, because again, once the plan is approved, the entire property gets sold by the termination trustee and conveyed to the developer. These people who are holdouts will no longer be owners. The plan has terminated the condominium, and they will get a share of the reasonable proceeds available for the purchase of the entire property based upon the plan of termination. And in many cases, yes, in many cases, the holdouts do better, but in some cases they don't. And I'll talk about that in a minute. But when it is a plan of termination, the plan itself essentially negates the objectors. Yes, they can file challenges through arbitration to the plan of termination, and they can do a number of things, hire lawyers and fight it. But I can tell you this, if there is enough owners who have sold so that a plan of termination can be approved by a developer, the handwriting is on the wall, the place will be terminated, the property will be sold, and they'll get their share. And the plan of termination under the statute does protect owners, that have held out. It's not like they're going to get a sharp stick in the eye. They'll get the value of their properties. So again, I'll talk about it in a minute. They are not in a bad position. Again, as I've dealt with plans of termination or termination under condo docs over the years, we do have owners who say, I don't care how much money you want to give me. This is I'll remember one up in way northeast Dade County. This is my bit of land and unit on the sand on the beach. You can't give me enough money to replace that. They no longer are owners, and they're large high-rise buildings that have replaced their little mom and pop condos many years ago. But let's talk now about when the statute doesn't apply. So when the statute doesn't apply, there's a percentage still that will allow for termination. What happens with the holdouts there? I alluded to it earlier. It's called partition. If you look in your condominium documents, you'll likely find a provision that says that the owners own the property in undivided shares, and there shall be no partition of the property. Okay, that's what the declaration says. Now the condominium is terminated by a vote of the owners. Again, a vote of the owners, really? No, a vote of the developer-controlled units where the developer has acquired enough property to terminate the property. What happens there? They go to court. They go to court in a matter called a partition action, something that before condominium partitions were a big deal, you would see mostly in divorce law. You'd have a husband and wife, they'd own a house, they get divorced. What do we do with the house? Other than one case I read about a husband taking a chainsaw and cutting down the middle of the house is indivisible. You can't say, wife, you get the north side, husband, you get the south side. So they go to court and a judge says, I'm going to partition the property and I'm going to sell it. And each of you will get proceeds based upon the percentage which I determine. So when it comes to a condominium, we've terminated the condominium property, and now we go to a partition action. And the court will engage in a process by which every owner or former owner, again, developer, the developer owns 80% of the units, the owners own, let's say 81%, the owners own, other owners own 19. Everybody will be a party to that lawsuit. And the court will then determine how to cut up the baby. And I will tell you that while I've seen developers say, well, if you don't take our deal, the court might give you that sharp stick in the eye. The courts typically, and when I say typically, and I've been involved in a lot of them, the courts will typically very much protect we even had a discussion in one hearing about whether to call them objectors, dissidents, or whatever, because again, it was clear that there was a group that didn't want to sell for the amount of money the developer offered. And the court went through a process and figured out a way to make sure that the units that were going to get bought up by the developer through the partition action, it would be a forced sale. There is no way in stopping it once you get to a point where partition is done and the number of units required have been acquired by a developer. But the court will protect all parties. Incidentally, they'll protect the developer too. The developer in a property, let's just say we have 120 units. They bought 100 of those units. They paid $100 million for those units, and the 20 holdouts say, I want more than $1 million for my unit. And the court will determine either through a process, the court might itself hire a commercial real estate broker to assist in the process. The court might hire an appraiser to determine what the appraised value is for the highest and best use. There's a lot of ways to go. But again, once you get to the tipping point, the objectors or the holdouts or the dissidents, whatever you want to call them, will be required to sell, but will not receive nothing, will not receive a way small amount based upon whatever the developer wants because they can stick it to them. That's not the way it works.
So it's always going to be fair market value minimally, but also depending on the valuation set forth in the plan of termination. So they're really never going to get, as you say, a stick in the eye. They're going to be taken care of. One viewer asked about what vote is needed for the developer to take control of the association. It really depends what you mean, because the developer just needs to buy a few units to take control of the board of directors through the election. But to take control of the building so that they can approve the termination depends 100% on this analysis that we've been talking about, that we have to see whether the old statute applies the current statute or the governing documents. In the case that David and I had that we talked about earlier, in that case, the developer believed the vote was 90% to terminate, and yet they were willing to move ahead with 75 or 80%, whatever it was, of the units purchased. So really, what percent is needed to take control is going to depend from building to building again.
Building to building, Rosa, and developer to developer. And they're both their lawyers and their realtors and the people involved. Because as you said, there was a business decision made to say, you know what, if we acquire enough, we'll go ahead and take the risk that we can't acquire the additional amount more to now force a sale.
Right.
It happens rarely, but it happens.
And talking about taking control of, enough to vote on termination versus taking control of the board. And this is a little bit outside of my experience, but I wouldn't imagine a developer would want to assume taking on serving on the board and all of the responsibilities and legal obligations that would entail and the risk that would potentially present in that type of situation. I don't know, it maybe varies.
They're not really going to necessarily own the units though, like they're not going to move to close the units until they have enough in their pocket of contract. So they're not owners. So unlikely that they're going to be able to, unless they purchase a few here and there, but they're probably not going to be able to take control of the board unless they also have enough votes to terminate.
Before we kind of wrap up with a few more questions, I do want to touch on, and you mentioned, you're going to end up in court on a partition, and there have been some court decisions dealing with termination. I believe there's one appellate court decision that deals with termination. And can you touch on that a little bit, both David and Rosa, give your thoughts on that?
I will say this, Rob. Rosa talked about the fact that there's a lot more terminations now. We'll see. But statistically, in the last number of years, there actually have been less terminations than in the, let's just say, the 1990 to the 2010, 2000, right around the time the statute changed, because the legislature meant for the statute to make it easier to terminate when they made the changes in 07 and 08. And then they tried to make it a little harder in 2017. In
Right.
neither case did they made it more difficult, especially when the termination statute applies, because termination under the condo docs is a little bit easier to address. But there was a case out of the 3rd district, which is where I am, which is Dade, Broward, and actually not Dade, Broward, Dade and Monroe County, which determined in that case that the whole part of that case was what applied, the statute or the condominium documents. And that court held that the statute did not apply. And again, it went through an analysis as to why, but it was a very odd situation because in essence, the condo owners wanted to terminate the condominium and sell the building, but it was right next to a major development, a Ritz-Carlton, and the Ritz-Carlton owned a couple of units in the condo and challenged the association's ability to terminate according to the statute, and they won. And the court said, no, the statute doesn't apply. It's the condo docs. In that case, the condo docs had a 100% provision, and that was that case. There are a lot of other cases that are snaking through trial court decisions regarding terminations. And I do agree with Rosa that while the statistics are that there's not a lot more terminations now than there were, that there will be a lot more terminations than there were. And again, we talked about the pressure points, SB4D, that's going to cost people a lot more money. Rebuilding after Hurricane Ian, and I still have people rebuilding after Hurricane Irma, the cost of rebuilding. We have one question, real interesting. Now, again, they call it the management company. They say if the management company pushes the condo fees to a point where membership can no longer afford it, the board then decides not to continue the association. Can the management company take over ownership of the property? Well, let's do this. Let's change the word management company to developer, because the only reason somebody wants to take over the property is to redevelop it in some format. So again, the answer is, it's a very insightful question, because as Rosa said, maybe a developer says, okay, I can't get to where I need to be, but I can get to a point where I can control the board of directors. What happens next? Oh my goodness, there's huge code violations. Oh my goodness, there's requirements for structural modifications because of SB4D. Here's your $10 million assessment. Pony up or sell us the unit. And
Right.
That's how they force people to sell, not from a court standpoint, not from a plan of termination standpoint, but from an economic standpoint.
Yeah. I saw another
Yeah.
interesting question. Oh, go ahead, Rosa.
No, I'm sorry. I was just going to say, because you touched upon it and we know that it's a subject for another webinar, but on the application of SB4D, you know, those of us in counties such as Miami-Dade and Broward that have been familiar with the 40, 50, 60-year recertifications aren't going to be entirely surprised or unfamiliar with the process that the new statute requires. Basically, it is going to be more expensive. You do have to have these milestone inspections. You do have to have reserves. And some of the reserves are unwaivable. And the only reason I mention all of that is because David just said he thinks terminations are going to be more the subject of in the future. And I agree, because even though we may not be talking about termination due to casualty, the optional terminations, I think, are going to be more popular now, because simply put, the expenses to maintain a condo are going to be significantly higher. And let's be open here. This really all came to pass due to the horrific tragedy in Surfside. It was, you know, the legislature rightfully determined that something needed to be done and addressed it this way by the implementation of SB4D, which due to the restrictive nature of the statute requiring expenditures and mandatory reserves is going to affect the pocketbooks of Florida condominium owners, undoubtedly.
You know, condominium ownership is the face of condominium ownership is and will change. And it's unfortunate because in many cases, or at least in many places, condominium ownership will only be for the well-to-do, people who can afford to spend more to live either on the water in, communities where, the amenities exist. And listen, I read an article yesterday about how people are flocking in the United States to buy property where? Fort Myers. Why? Because despite the hurricane, they see value, they see beyond, the fact that there was a terrible loss. And again, we've had terrible losses before. Hurricane Andrew, Hurricane Opal, even in the Southwest coast, Hurricane Charlie. But, rebuilding will occur. The rebuilding will be bigger, better, stronger, and more expensive.
Yep.
David, just because you live in a single family home, don't frighten us folks who live in a condo.
There was a question at the beginning of the question and answer list about, given the hurricane, do we think there's still going to be a demand for, development on the water? And it's, I'm not a real estate appraiser, but the history of Florida says yes.
We know what realtors say, Rob: location, location, location.
Yeah.
And whatever your politics may be about Florida, Florida is still Florida, and people will want to come here.
Yeah, absolutely. So we're going to see, the redevelopment of even the barrier islands, after this. One of the other questions I thought was a little interesting, because this is a provision in documents that we add with some frequency, is the question was, if there's a provision in the documents that limit the number of units that a single person or entity can own, how would that come into play? I don't have any specific experience with that, but I think it's a practical matter. And I'll give you my thoughts, and you correct me, David.
Sure.
As a practical matter, if the developer can buy 85% of the units on contingent contracts, that provision is going to be functionally irrelevant. I mean, that's just how it's going to work.
Yeah, and number two, they can amend the documents, because if 80% want to sell, 80% will want to amend to sell.
Right, but we add those provisions over here with some regularity, particularly following the real estate meltdown in 2008, because you just don't want, you're really less worried about a developer buying out for termination. You're more worried about someone, making your condo their private apartment complex with 10 units, and then they stop paying assessments one day. But I thought it was an interesting question, because we do see those provisions.
And that's what we've seen, Rob. On the one side, we see clients who want us to amend documents to have a multiple ownership restriction. And on the other side, we see developers coming in and saying, what are we going to do about that? And the answer is exactly what you said and what Rosa said. If they can get enough units to terminate, they can get enough units to amend those documents and get rid of that provision.
Right. And the same thing, there was a follow-up question in here about, approval of purchasers by the board. I mean, that's also going to, just not be a way to prevent it.
Yeah, these are all little details that occur during the process of somebody trying to acquire a property. All very interesting stuff, mostly for condo lawyers, but yeah.
So we're at 2:00, and I just, I think we kind of want to start wrapping it up. I mean, I think the main takeaway for the associations, in my mind at least, is setting aside the termination due to casualty, which has its own specific drivers and issues. If you're in a building that gets approached, or think you want to, market yourself to be approached by a developer, you really need to take these issues into account. I think you need to put together a plan on the front end on how you would want to do that or react to that if you get approached with it. We're going to see more of it. I think it's just an inevitability, given the issues we talked about, and just the fact that we have an aging housing stock in some of the prime locations in the state. And we're going to see more of it, and they're going to be disputes come out of it, but ultimately we're going to have to deal with the fact that some number of condominiums that exist today won't exist in the future. Closing thoughts, Rosen and David?
Sure. My closing thoughts is to give everyone a little bit of homework. Go to your declaration of condominium and read your repair after casualty language. Educate yourself as to whether you have a default provision forcing you to terminate without an owner vote. You need to know that. And if you have that, consider amending that bad provision out of your documents. And the number two homework is to read chapter 718, 117. It's a lot of sluggish, dense reading, but it sort of will familiarize you a little bit with terminations. And I do think that it is the wave of the future. So we should all sort of be able to embrace the concept a little more. The more you know about it, the better it is if you are approached.
And again, take care of your building, take care of your owners. You have a little slice of paradise. Terminations will happen. It doesn't necessarily mean that everybody's going to be forced out of their properties. And suffice to say that the process is protective of all owners, but you need to understand the process and the details thoroughly to wind your way through the process when a termination and sale is in the future of your condominium. Thank you all.
Well, thank you all for attending. We appreciate you participating and all the questions that were submitted. We'll keep the questions for the future potential programs.
Thank you.
Bye-bye.